So in the current force majeure situations that is occurring in due to the tensions in the Middle East, we'll be seeing the topic of negotiation strategies for employers and PMCs in force majeure claims from the contractors. So force majeure today is no longer a black swan, and it is a very repetitive pattern. We get it normal. So often we get global tension, supply chain disruptions, regulatory shocks. It becomes a live commercial battlefield that you have to keep updated on force majeure situations. Employers and PMCs who treat it just as a legal formality will end up in later issues for sure. So how to handle this with the strategic approach? First of all, reset the negotiation object. Stop focusing only on the entitlement. Focus on the exposure. So a force majeure event occurrence doesn't give the leverage to the contractor to take a cover under force majeure. The contractor has to prove that the force majeure has damaged them and made them not to perform the contract. So the most contractors will anchor the discussions around EOT, prolongation cost, escalation requirement. This is very normal in the industry. So as an employer in PMC, what we should do? We should reframe. So what is the minimum acceptable delay impact? What portion of the cost is truly unavoidable versus opportunistic? So what is the unavoidable cost and what is an opportunistic cost? Can disruption be commercially traded off? So whether you can trade for the scope, whether you can trade for acceleration or squeezing. So shift it strategically. So move from is FM applicable to what is the least cost path forward. So I'm not trying to phrase that a cost is must, but enter in the mindset that cost will have impact. But you're not going to pay unless it is proven, unless it shows the linkage between the cost and the effect. So control the narrative early. Use standard contracts. You might go with FIDIC, JCT, or NEC, or any structured contracts which is used by large employers. The PMC strategy should be that immediately issue engineer's position on the paper, challenging these arguments in the force majeure. Like what is the cost, what is the effect, what is the entitlement, and what is the evidences. So these has to be challenged with the engineer. Don't sit silent on the records. I've seen most engineers, they get force majeure and they'll be silent on that. That doesn't mean that it is a response. They either reject or stay silent. Please don't do both. Respond them properly under these 4 sections. So the contractor bundle, the segments, the force majeure events, always. But do not handle them as a single package. The first is the true force majeure component. Second is the gray components which are negotiable. Third one is the contractor risk events which are hidden. So first is the government regulations, port closures, war escalations, related restrictions. The gray zone is always supply chain inefficiencies, subcontractor failures, late procurement decisions. So these are all the gray areas because it might be due to the mistake of both the ones, or it might be due to the mistake of the force majeure also. So that's why it's a gray zone. The contractor risk is that whether it was a poor planning from the contractor that ended up for us to have this effect under force majeure, or any financial distress that pushed to this situation, and lack market sourcing delays. So the negotiation strategy should be that A, you have to mindset to accept. B, it is hardly challenging. You can negotiate on it. C, you can straight away reject one. So use without prejudice commercial frameworks always. So instead of going for binary, I accept this, I reject this. Structure the commercial settlements such as partial cost sharings. Okay. Let's go with the 50% on this logistics. And lump sum disruption settlement. Rate rebalancing for the future products. For example, let's take an EPC scenario. Instead of paying the full prolongation cost, the employer grants 90 days EOT Okay, that means no LD, pays a limited site overheads. The contractor absorbs head office costs. So the outcome is it avoids arbitration exposure while preserving project. You can negotiate with the contractor. See, I'm just speaking in terms of project execution and business running. See, both the parties has impact on this force majeure. And contractor has to give something out for the client, and the client has to settle something for the contract. If you see in the perspective of arbitration, if it is right or wrong, that's different. And you are going to end up in a full cycle of arbitrations, and if it's going to still you will be a 50-50% win, and it still goes to the end of the federal court or the Supreme Court, the highest court to get the order. That we don't want in the PMCs to do. That we work for the projects to thrive and grow. So in that point of view, you put a hand on the shoulders of the contractor and see that these are all I can do from my side, and these are the things you have to do from your side. So that's how it works. So leverage time over money. So in force majeure, we always think EOT is easier to justify than cost. No, justifying EOT is very difficult under force majeure. So that is easy to challenge a contract because linking somewhere a force majeure event occurred and how did it directly affected your progress in this site has to be proven, which is very difficult. So usual employee strategy is that they offer EOT, that I offer EOT, you don't ask, I don't levy LD and you don't ask prolongation. But this is a usual discussion all over the world. And usually in public sectors where they are the employees. But it is a bit difficult when you go for private sectors. Both are private sectors because they are doing business and they want to do business for a long time as partners. So keeping that in mind, so introduce conditional EOTs. So when you provide EOT, don't give it very generously or only keeping liquidated damages in mind. So don't be conservative on the cost. You forecast the project to be complete. See, always think if a faster completed project will gives you more revenue than you think about the prolongation costs and the liquidated damages you are thinking. The people who are actually in the projects, they don't know about the capex. They don't understand about the cost or the revenue that the plant or the project is going to generate. That's we have to give them a training. Only then they will understand whether this delay is acceptable to us or whether this damages will feed us something. So we have to see in that point of. So EOT granted subject to revised mitigation plan and linked to source ramp-up commitments. See, you always make strict resource plans in the EOTs. If any deviation from the resource plans, that will revise the EOT acceptance. So that has to be very cautious. Most of us, we don't negotiate on the resources. You have to be very cautious on the resources because an EOT is a floodgate that always give opening for other EOTs. Most of the contractors don't settle for a single EOT. So let's be very cautious on that. And force mitigation commitments. See, mitigation is always the mandatory requirement under contract. It is a mandatory obligation for contract. So the contractor should not directly say mitigation is not possible due to the force majeure. This must be challenged technically. So as a PM, so you can demand the mitigation actions taken from the contractor side before moving into the actual damages and compensations. So the first level of negotiation should be on the mitigations. So no mitigation, the contractor is not entitled for no full entitlement. So under most contracts, failure to mitigate weakens the cost claims significantly. So as a PMC and employer, your focus should be on the mitigation. See, not just to protect your positions or protect your interest. You just see in the point of a project perspective. If something is mitigatable and that saves millions of money, and who is the best artist in mitigation is the contractor because he is the executor. He knows what to do, when to do, and how to do than the employer. So then introduce open book verification. This is actually most of the large companies, even though the contract doesn't say that we verify your black book or we see audits from your financial papers to identify what is the actual cost. There will be always a debate when the contractors also has a bargainable power equal to them. But if you see, if the contractor is not using the situation just to make more money, he will be generous enough to open the black books. Anyway, if you end up in arbitration, you have to show the black books. You cannot play that this is my cost, I just given theoretical cost. If you are really damaged, I have seen many contractors who got real damages, but still they will be reluctant in showing their black books. They think that this is a trade secret and we will not be sharing with the employer. No, this is not a trade secret. If something has went above your overheads and you are not able to handle it, you have to sit with your partner who is the client and then you have to expose the black. As a PMC and employer, you have the rights. See, I am ready to pay the damage. See, whenever you ask for a black book, you should be in the mindset that I can pay the damage if you can show the black book. The black book is the last stage of evidence. You should not ask in the first stage. First, you have to do with mitigation. The second is the cost. Okay, even the mitigation, you got an impact, the effect. And then next you go for, so okay, what is the entitlement of the contract? Whether the contract is giving the entitlement, whether we have shared the risk in the contract. Then the final stage is evidence, which goes for the open book verifications. Use contractual delay as a strategic tool. The large employees and PMCs know this always, and they use this always against the contractor, that they bring concurrency under force majeure or concurrency under the change in law to make the prolongation cost nil. Usually inside the projects, a delay will not occur solely. The problem is you can't identify them based on the inputs available. But if you put some time and efforts to identify the concurrency delays that were in the side of contractor, then you will not end up in any additional costs due to their performance, additional performance under force majeure. See, under force majeure, you don't have the cost entitlements for sure. But if the force majeure resulting in change in law, and change in law is requesting additional precautions to be taken by the contractor and continue the work, that creates a cost entitlement. And that too has to be proved. So avoid precedent traps. So please be always careful in sending concessions, like it should not be a floodgate that the contractor will not come up with the other claims similarly. Prepare for dispute while negotiating settlement. It's a good attitude to always focus on the settlements and negotiations. But that doesn't say that you should not be parallelly getting ready for the disputes. So we used to say, advise our PMCs and employees, even though you are negotiating with the contractor, okay, get ready for the arbitration. If it doesn't happen, it's good, you are happy. But if it happens, we should not be in a weaker position. So always build a defensive claim file parallel. Even though you are going for a negotiation. See, negotiation is top priority. We have to run the business. Second, if the opposite party doesn't convince or he wants us to drag to arbitrations, then we should not be weak. So that is the theory. And a party will negotiate with the other party when he feels the other party is as strong as him. If he feels the other party is weak, he never negotiates. He tries to play the power game. And that is more important, that we should not be weak and our strength is always identified by the evidences. So, okay, what are the strategic trade-off? Okay. If you give UOT, okay, waiver on the prolongation cost. You give partial cost and you get the acceleration commitment. Variation approvals, withdrawal of the FM claim. Advance payment, then you have to ask for resource mobilization. So these are the very minimal strategies you have to follow on trading off in force measures. So what are the common mistakes employers and PMCs make which has to be avoided? Accepting force measure without causation analysis, straight away reject them. Ignoring notices, non-compliance. If your contract has strict notice timelines, please follow them. Paying unverified prolongation costs. Never pay them the theoretical cost. Treating PMCs as passive certifier instead of strategic negotiation. So use PMCs, power your PMCs. Don't just keep them as an advisors or not utilizing them fully. So delaying response which weakens contractual questions. Never be silent, always be communicative and use these strategies to negotiate with them. Just rejecting you doesn't put you in a good position. Many people think that we reject the PMC claims and we are in good position. You are not in a good position if you reject, unless otherwise you challenge. So closing insight is force majeure is no longer purely a contractual class. It is a commercial negotiation platform. The most effective PMCs and employees do not deny the reality. Okay, do not accept claims blindly. They reshape the commercial outcomes through structured negotiation. Thanks for watching. Comment if you want to know any other topics to be discussed. We'll discuss later. Take care. Bye.